Double patenting or obviousness type double patenting, that is ODP, is a judicially created doctrine by US which prevents the monopolization of inventions that are mere variations of the earlier patents and are not patentably distinct. So if both the patents are commonly owned by the same inventor, then in that case the ODP kind of objections that's been raised by the USPTO can be overcome by filing a terminal disclaimer which disclaims the portion of 20 years of the term of the second patent, and that extends beyond the term of the earlier expired patent's term. In a significant case of Astrazeneca versus Intas and Alkem, the issues pertaining to double patenting and coverage disclosure dichotomy was brought up, wherein Delhi High Court denied interim injunction to Astrazeneca. This matter pertains to two patents, IN 147 and IN 625, of an anti-diabetic drug, dapagliflozin. Whereas IN 147 was a genus patent, IN 625 is a species patent, and the compound therein forms a part of the Markush structure that's claimed in the former. Given the fact that IN 147 had already expired, IN 625 awaits expiration on 15th May 2023, and therefore it was Astra's contention that the defendants had infringed upon the species patent. So the defendants argued that IN 625's validity was questionable since IN 147's monopoly had concluded and the drug disclosed in IN 147 was the same as that in IN 625, and therefore interim injunction be rejected, to which the plaintiff rebutted that the drug dapagliflozin was covered within the Markush structure of IN 147 and was specifically disclosed and marketed only under IN 625. So Astra's stand was great commercial success of the drug, patent examination for over 7 years, several injunctions against third parties who infringed, and no pre-grant or post-grant opposition in 15 plus years of the product life cycle. What needs to be reiterated here is Section 64, which contemplates that the patent can be revoked on a counterclaim against its validity via a suit for infringement, and that the patent is valid only till such time that it is challenged. And this was brought up in Roche versus Cipla. It was stated by Intas and Alkem that when ODP objections were raised by USPTO at the time of filing US 117, that is equivalent to IN 625, the plaintiffs had filed a terminal disclaimer, and to which the plaintiffs argued that it was just a methodology to overcome the objections of USPTO and not an admission to double patenting instance. Defendants also stated that IN 625 was anticipated by what was published and known from IN 147. Also says that it does not identify any unknown technical effect in producing the drug, and they also brought up US infringement suit wherein it was stated that manufacture of dapagliflozin would infringe upon certain claims of US patent 126, which is identical to IN 147. Also in furtherance, the court held that crossing the threshold of examination is not the ultimate test of validity, and the age of patent did not strengthen the firewall around it. Section 64 further contemplates that the patent can be revoked on a counterclaim against its validity in a suit for infringement. Also further, that the patent is valid only till such time it is challenged, and as observed in Roche versus Cipla. So although ODP was brought up before the Honorable Court owing to the USPTO objection that was raised during the filing of US equivalent of IN 625, what needs to be understood is that the drug has escaped scrutiny for 17 long years despite of the high threshold Section 3D of the Indian Patent Act. It is quite pertinent to note that Section 10 subsection 5 says that claims shall be fairly based on matter that's disclosed in complete specification. Section 64 subsection 1 read with Section 13 subsection 1 says that only coverage of the subject matter by a prior claim is sufficient for revocation, and disclosure is not stated as a requirement. Well, although the court brought it up as citing ODP issues, it's quite akin to the high threshold Section 3D of the Indian Patent Act, which is majorly to curb the evergreening of patents. This works on preventing patentability of inventions which are mere and trivial alterations to the already existing patents. ODP, a judicial doctrine that's created by US, is to prevent the extended monopoly period of the second patent after the earlier patent expires. So principally, it's acting in a similar way to Section 3D of the Indian Patent Act, just that it allows filing of a similar invention by filing a terminal disclaimer. But why in the first place is it allowed? Is a matter worth probing. However, it's rather surprising that it has escaped scrutiny for 17 long years.